Welcome to Live Free Legal. I'm Tiffany Lesnik. I'm a licensed attorney in the state of North Carolina who's worked extensively in the areas of high conflict custody, alienation, domestic violence, and post-separation abuse. Not only am I a domestic violence attorney, but I'm also a survivor of domestic violence. I'm going to share with you my personal and professional experiences to help you change the outcome of your case for good. We've been talking a lot about domestic violence in the law, and today we're going to talk about the best evidence to collect in cases involving domestic abuse. We have a free gift for you today. It's my guide called Top Lies Abusers Tell. Created the link below to get a copy of your free guide today. I created a top 6 list that I think is the best evidence to collect in cases of domestic abuse. Number 6, you've had to seek medical treatment or go to the hospital. You certainly can bring a bill to show when you were injured, the type of injury you sustained, and how much you had to pay for that. It could be also for therapeutic services. So let's say you're just going through severe psychological abuse and you're seeing a therapist in order to deal with that trauma. You could use those bills to show that you're needing therapeutic services because you're undergoing substantial emotional distress. Those bills may need to be certified in order to get them admitted. So that is just something to be aware of. You may also have bills or invoices for damages that the abuser has caused. It could be that he's damaged the house in some way, and you've had to have a contractor come out and repair doors or repair walls, or maybe he's damaged your car in some way and you had to take your car to an auto body shop. All of those bills can be used to show damage that has been done. There is one warning about the bills for medical or therapeutic services. It's very important that you do not file or introduce into evidence your actual medical or therapeutic records. By doing that, you could be waiving your HIPAA protected privilege to those medical or therapeutic records. I've seen people that have actually filed their personal medical information in the court file. Do not do that. A bill is not in and of itself a medical record. It's part of a medical record, but it doesn't waive the same kind of confidentiality and privilege that an actual medical record will do. Number 5, criminal and other civil records. So if your abuser has a criminal history, it would be important to potentially have some of those criminal records to show the court what kind of criminal past does he have. Be focused on what's relevant and important. So if he has a couple of speeding charges or driving without a license, those are not going to be all that relevant to a domestic violence protective order hearing. You're going to want things that show that he's dangerous in some way or maybe has problems with substance abuse, assault, anything involving violence, those kinds of crimes, anything involving drugs, substance abuse issues would be important. Other civil records. Has he ever had a protective order entered against him before? Has anyone ever filed a case against him for damages that he's caused as a result of his behavior? What things are in the public record or the court record that would support your allegations that he is violent or out of control in some way? It can be very easy to get those types of records admitted, and they're very important. They tell a history and they tell a story. Number 4, most people don't about using witnesses and or your own testimony to tell your story as a form of evidence. But your story and your testimony and the way you present to the court is a form of evidence, and it's a good form of evidence. It's very important that you know how to tell your story. We're going to do a separate video session on that, learning how to tell your story and what makes you a good witness. Other witnesses might be teachers at your children's school, might be your neighbors, it could be family members that have seen you in distress, that have seen the way that your abuser interacts with you or the way that he behaves around you or your children, that can testify to those things that they've personally seen. You might also be able to bring in your children's therapist as witnesses. I think children's therapists are a better use of the court's time than perhaps your own therapist. You run into issues with HIPAA-protected privilege by bringing in a therapist or bringing in your own physician to testify. I'm not saying you can't do it or that you shouldn't do it. Just be aware that if you bring in your own medical provider, whether they're a mental health provider or a medical provider, you could be potentially waiving some of your medically protected information. Number 3. Copies of text messages or emails. basically anything that's in writing. It's very important that you take a screenshot or a printout of those text messages or those emails. It's important that those screenshots or those printouts have the date and the time, and also the people communicating in those messages. So his name, your name need to be clearly visible, as well as a date and a time, or you may not be able to get those admitted. It's important to show the substance of what he's saying. Is he making threats? How is he speaking to you? Is he demeaning? Is he cussing at you? Is he calling you names? The content of the message is important, and be mindful that what you say matters as well. If he's calling you names and then you're repeating it back, calling him names in retaliation, or you're just upset and you're trying to get your point across, those messages may not be good for you. It's really important to be mindful about what you say in your messages with him, because they could potentially hurt you. Another thing you could use with your text messages, and potentially with your emails as well, is the number of times he's messaged you. You can take a screenshot of your phone that actually shows he's texted you 20 times in the span of 2 minutes. Excessive numbers of communications are inappropriate, and it's not something that reasonable people engage in. You can also do that with emails. If he's emailing you over and over and over again, you can show, hey, look at the number of emails that I have in a very limited period of time. It just shows his lack of emotional control and his impulsiveness, which goes to his erratic and abusive behavior. When you are taking screenshots on your phone or email, be mindful about what he is called in your phone and what you have his picture or his avatar. We don't want to have his picture or avatar be a picture of Satan, and then his name listed beneath that is the devil or something like that. That could also harm you in court. Number 2, I highly recommend, when things are happening, to take pictures or photographs. You can take photographs of bodily injury. So if he's harmed you in some way, if you have any kind of bruising, lacerations, any markings on your body whatsoever, blood, take pictures of that. So if he hits you and blood ends up on a piece of furniture, on the wall, or on the floor, or anywhere like that, take a picture of where the blood ends up. You also want to take pictures of damage to property in the home. So if he's punching holes through the walls or banging down doors, ripping the blinds off walls, whatever he might be doing to the home, make sure that you're documenting and taking photos of all of that damage. Maybe he's ripped up clothing. He's broken things like chairs or plates or other personal property, photographs, ripped things up, thrown your personal belongings out into the yard. You can take pictures of that. If he's burnt items, you can take pictures of that. You can also keep those things and bring them to court with you, like in a large Ziploc bag or some other kind of bag. If he's done damage to your car, if he's keyed up your car, if he's slashed your tires, perhaps he's run into your car with his own car, that's something else you can take pictures of. Alcohol, drugs, or other types of illicit substances within the home. Make sure that you document that, because alcohol and illicit drug use increases the propensity for violence, and it also increases the propensity for people to act erratically and in scary ways. That can go to help support your argument that he is violent and scary, and that you're afraid of him, and that his behavior escalates when he's drinking or using any kind of drugs. I will issue a warning about pictures with children. The court generally gets very upset when they feel like children are made to pose or stand or do anything that would make them uncomfortable in order for you to be able to document evidence. So especially if it's in a really private place, you need to be very, very careful with how you're taking pictures of physical damage to your children. I would recommend, like, if they're sleeping and they're unaware that you're doing it, or perhaps they're playing and you're behind them and you just grab a quick picture of their leg or something like that. But we don't want to be propping them up and making them pose and re-traumatize them by then taking photos of them. And then be mindful of their privacy as well. Keep their underwear on, keep some of their clothing on. You don't have to strip them completely down and be taking pictures of them in that manner. The court usually is not going to appreciate those kind of photographs. Number one, your abuser can come in and be the most charming, charismatic person to the court, to your neighbors, to your family members, to the church members. But when you have an audio recording that shows his true nature, there is really nothing he can do to undo what he sounds like and what he's saying in that recording. So you can do an audio recording or a video recording. Now, be mindful that you are also in that recording, so you need to be careful with how you're responding if you are making a recording. You don't want to be in there following him around, harassing him, nagging him, interrogating him, cussing him out, making threats. Those are not recordings that we can use. There's one big issue with audio and video recordings. There are laws, federal laws, and also individual state laws that mandate how recordings can be made. And so there are certain states that are one-party consent states, which means that as long as one party is present and consents to the recording, then you can make a recording of another person, even if they don't know you're recording them or they don't consent to the recording. Then there are other states that are mostly called two-party consent states, but it's more appropriate to call them all-party consent states, because everyone who's depicted in the recording must consent to the recording. If all parties in those states do not consent to the recordings, then it is illegal to record without their consent. You just need to be very careful and seek the advice of an attorney in your state to ask about other ways of collecting that type of evidence. Now, this is not an exhaustive or all-exclusive list of the types of evidence that you could be collecting in domestic violence cases. There's lots of other evidence that you can use. We're going to have other episodes where we'll talk more in depth about evidence that can be used not only in domestic abuse cases, but also in child custody cases, financial cases, property distribution cases, all of that. So I'd encourage you to continue to tune in as we learn more about different types of evidence that we can use in court. We hope that you felt empowered today and that you will join us next Tuesday at 7 p.m. as we explore when is it legal to record my spouse for court. Remember to click on the link to get your free guide, Top Lies Abusers Tell, and get started on your legal empowerment journey today. Make sure to give us a thumbs up and subscribe to our channel for updates on upcoming videos. I'm a licensed attorney in North Carolina. I cannot offer legal advice outside of North Carolina. The purpose of these videos is to offer general advice, not legal advice, to help you improve your legal outcomes. I would encourage you to seek the advice of an attorney in your area if you need additional help. Remember, you were created to live free, not in bondage. Join us next time as we continue to learn more, support one another, and continue to move from fear to freedom.